Mary Ryan, who is expected to arrive imminently, and Donna Padalata. This evening's program has 6 co-sponsors: 3 Leagues of Women Voters of Arlington, Lexington, and Winchester, Arlington Community Media Incorporated, also known as ACMi, First Parish Arlington's Mass Incarceration Working Group, and for the District Attorney debate only, the ACLU of Massachusetts. Our purpose tonight is to support educated voting, which is essential to our democratic form of government. We will have 2 debates tonight. We will start with a 20-minute debate between the candidates for Governor's Council. The Governor's Council provides advice and consent for a variety of appointments and decisions made by the Governor. This debate will be moderated by James Milan of ACMi. We will then have an 80-minute debate between the candidates for District Attorney. District Attorneys are the lead prosecutors for their counties and the most powerful individuals in the criminal legal system. Your booklet has details about what they do. This debate will be moderated by Patty Muldoon, who is a trained facilitator of the League of Women Voters of Massachusetts and the Vice President of the League of Women Voters of Arlington. For each debate, we flipped a coin with the candidates to determine who will go first, or otherwise chose in a mutually agreeable way who will go first. I want to make sure you know that the primary election is very early this year. It will be the day after Labor Day on Tuesday. For the primary election. All of the candidates for these offices are Democrats, so the primary election on September 4th is the decisive one. We hope this evening will give you useful information about the candidates for these important offices. Please talk with your friends, share what you have learned, and vote on September 4th. Most of all, thank you so much for being here this evening. We are all very grateful.
Hello everyone. As previously mentioned, I'm James Milan from ACMi, and I will be moderating tonight's Governor's Council debate. Just a quick word about the format. There will be opening statements of 1 minute each from the 2 candidates, and then we will have a series of 4 questions. The candidates will have 90 seconds each to respond to those 4 questions, and we will alternate the order of the questions, or who answers first throughout the 4, and then we will close with 2-minute closing statements from the 2 candidates in reverse order from the opening statements. By mutual agreement, it was determined that Mr. Carter would proceed first with his opening statement, and we invite you to do so now.
Thank you. Can you hear me? Can you hear me? Well, we're gonna go ahead. I'm Nick Carter. I'm a lifelong Democrat. I'm running for Governor's Council against the 20-year incumbent. The Governor's Council ultimately determines who our state court judges are, our parole board members, and our clerk magistrates. I have the experience and passion for this job. I'm a 25-year trial attorney. I have worked and appeared in nearly every court in Massachusetts, handling both civil and criminal matters. I care deeply about our justice system. My first priority is to ensure excellence and to protect our Massachusetts values. We need the finest judiciary possible. As Donald Trump radically shifts our Supreme Court and federal judiciary to the right, we need a state court that will protect the values and legal principles we care about, including a woman's right to choose, gay marriage, common sense gun control, and enforcing environmental regulations to reduce carbon pollution. I hope to earn your support. Thank you.
Thank you very much. Mrs. Devaney, please hold your applause.
Thank you. I'm Marilyn Petito Devaney, and I'm honored to be your governor's counselor. I am respectfully asking for your vote on September 4th to continue to use my experience working for you, being your voice. I am the only full-time. I meet with every nominee for 3 to 4 hours. I've made reforms change Parole Board, stop counselors accepting monies from nominees when applying, and it's all in governor's executive orders. Establish the first public Governor's Council website. Swear in nominees and witnesses at their hearings. I attend Parole Board hearings, court, prisons. I testify on criminal reform bills, for example, against minimum mandatory sentencing. Thank you for your time.
Okay, we will proceed right to the questions, and the first question will go to you first, Mr. Carter. It is, one of the primary roles for the Governor's Council is to provide, as you mentioned, advice and consent on a variety of gubernatorial appointments, including judges and members of the Parole Board. Please explain what part the Governor's Council plays in this process and what you think works well or doesn't in the system as it currently functions.
The Governor's Council receives nominations for these important offices from the Governor. The Governor's Council ultimately must decide yay or nay on these officers. I want to be proactive, pushing back on whoever the Governor may be to ensure we have the right judges. For example, we have just passed important criminal justice reform legislation on a bipartisan basis. Now we've moved the decision-making on sentencing to the judges. We need judges who understand we can't incarcerate our way out of the drug problem. We've been trying that for 40 years. We need judges who will look for treatment for folks with addiction, mental illness, people who are low-level offenders, nonviolent offenders. We must try a smart, practical, and different approach.
Okay, thank you very much. I just want to remind both candidates that if you can stay as close to the podium and those goosenecks to the other speakers as possible, that's easier for us to be recording you as well. Mrs. Devane.
First of all, I want you to know the Governor's Council does not choose judges. The Governor appoints 21 lawyers on the Judicial Nominating Commission, faceless, nameless people, and they have the authority when you submit your application to be a judge or a clerk magistrate, and they decide if you're going to get an interview, and they decide who they're going to vote for to recommend to the Governor. So we only get one person to vote yes or no. That's all. We don't choose the judges. I think that I feel that it's the Massachusetts Constitution that gives the authority all to the Governor, and it's very frustrating. Just recently, we had the most qualified person ever before me in 19 years for the Housing Court. This was the 4th time that she applied. I didn't know that. And so she's gone through the J&C 3 other times. I thanked her for reapplying. I'm proud of my diversity, and I have just voted for 2 women, which is first time, with from India roots, one to the district court, one to the Superior Court, and today I interview everyone, and today I met with over 3 hours with someone that is born in Haiti. So it's important because that judge has to reflect the people who come into the court. And we don't vote on issues. We don't vote on climate control or anything else. We only vote on judges, clerk magistrate, parole board, industrial accident board, pellet tax board, and pardons and commutations, justice of the peace, notaries, and oversee veterans.
Sorry, we'll have to move on.
Okay.
The second question is going to you first, Mrs. Devaney, and it is, what qualities or characteristics do you look for in a prospective judge?
First of all, they have to be honest, and I look for qualifications, experience, compassion, believe in second chances, and also when I talk to the nominees, I talk about drug addiction, because if they don't understand drug addiction and rehabilitation, they shouldn't be long on the bench. And I have been a big advocate. I can't vote for it because I'm not a legislator, but I lobby for more drug treatment centers. We only have about 3, and it's a medical problem. And I also ask if they are in favor or opposed to minimum, maximum sentencing, which I am opposed to. I don't think one size fits all. So I think you have to put it all together. They have to have compassion, and they have to have the legal background, and they have to have an understanding of opioids and what is happening in our society. So, do I have more time?
You have 20 more seconds.
Oh, so, but it is important because the thing is that I only can vote on this one person, and it's an awesome responsibility. And I believe those 21 members should all be present when they vote for someone to have a lifetime position. They recommend to the governor, and I've been outspoken about that. That's very important.
Thank you very much. Mr. Carter?
Yes, thank you. What I'll be looking for, supposed to stand here. What I'll be looking for is, at the trial court level, experience. We need folks who actually had trials and handled trials or have been advocates for a justice organization or worked in a governmental organization. We need somebody who works hard, because the job of a judge is hard work and they are understaffed. So you need somebody who's going to roll up their sleeves and work hard. You need someone with integrity, because our whole rule of law depends on people trusting that judges are not doing this to line their pockets, but are doing it for the common good. We need humility and people who will treat everybody who comes into the courtroom with respect, because you earn respect by giving respect, and the courts need respect and compassion. Because while in a criminal case you need punishment and deterrence at times, you also need to find a way to rehabilitate, bring people back into the community. That's got to be our goal. Now at the SJC, our highest court, I want to make sure that, and we're going to have a vacancy in the next term, and the Chief Justice within several years, we need to make sure the folks who get on that court will uphold a woman's right to choose, gay marriage, will allow common sense gun control, will enforce climate change laws that are on the books. That will be difficult but necessary. That's what I'm going to look for.
Thank you very much. Question 3 comes right back to you, Mr. Carter. How important is it for the Parole Board to include people with expertise in psychology, social work, and addictions? And please explain why you think as you do.
It's absolutely critical, and we don't have enough people on the Parole Board who have a background in these disciplines. We all know, I believe, that part of our problem in excessive incarceration is mental illness and drug addiction, and we have not yet accepted that reality. We need more people getting parole, more supervision. So this would allow people to get out of prison early from a sentence under supervision. That's what people need. What we're currently doing is running someone to the very end of their sentence and saying, have a good life. And it doesn't work out. A huge percentage of folks are coming back very quickly to our prisons. Our recidivism rate is off the charts. We need to address the addiction problem and the mental illness problem, and Parole Board members with a background in social work, in psychology, in psychiatry will help that process. We need advocates for this, and that is critical to moving in the new direction that our criminal justice reform bill is trying to move us toward. We need more advocates on the Parole Board who will help there.
Thank you very much. Mrs. Devaney?
Thank you. When I first got elected, and I'm the only full-time counselor, and I looked at the Parole Board, and they were all prosecutors, and I knew something was wrong. And I went to the legislators, and I changed it. And now we have someone who can identify inmates' mental problems, learning problems, addictive problems, so that we can prepare them to re-enter society successfully. And that's very important. I go to Parole Board hearings because I want to know these people that I'm voting on, how are they conducting themselves? and I had been very impressed. I better not get into that because you're going to get the hook. But I also go into prisons, and I also have met with former inmates to see if they're getting the follow-up that they should deserve. So I think that my biggest beef is that for years I've been asking for pardons, and this governor hasn't given one. Patrick gave us 6. It's unacceptable. If you go in my office, you'll see drawers full of names of people who've been approved by the Parole Board. They probably go back to Welt. Some of them probably have died. And yet, I can't do anything because the Mass Constitution says the governor has the authority. So there's a lot of changes that I would like to see, but he has the authority. Thank you.
Okay, thank you very much. And for our last question, we'll start with you, Mrs. Devaney. And the question is, what do effective members of the Governor's Council do, and what qualities do you think the public should look for when evaluating whether a candidate for Governor's Council is likely to be effective?
Well, I can't talk for other councils. I can talk for myself. I am the only full-time counselor. I meet with every nominee in my 19 years from Parole Board to Governor. I met today with someone who's going to district court who is a Haitian American woman. It's very important to me because I am voting for the whole person. Now, if you are a lawyer and you're an elected Governor's counselor, guess what? The law allows you to go before the judges you vote on. Might be legal, but it's wrong. And so I am independent. I'm not a lawyer. I work for you. I answer to you. And I think my commitment and my dedication in going further and looking into criminal justice and testifying in the State House on those different bills, I think it's important for me to know as much as I can, to go into the prisons and to see what's going on. And I'll tell you, our sheriff is great. And he has separated the younger inmates from the older, so they don't learn the old tricks. And it's really working. And so I work with all these people and reps and senators who have helped me when I tried to change the Parole Board. All of those things, it's all working together. But because I'm full-time, I am investigative, and I know the boards, going to the Appellate Tax Board or going to the Industrial Action Board, I know. And our Industrial Action Board is the best in the country.
Thank you very much. Thank you.
Okay.
Mr. Carter?
A governor's counselor needs to have experience. You are involved in selecting and approving some of the most important people in our government. You need to know what you're doing and what job these judges do. I've been doing that for 25 years. I know what makes a good judge and what makes a bad judge, what doesn't work in our courts, and I want to correct it. You need somebody who's willing to stand up and fight for what's right and for values and push back against the governor and go to the media and say, we've got a problem. Let me give you an example. I'm a white guy. I go into court. A lot of people look like me in authority. That's a problem. We don't have enough diversity. We need more women trial judges. Only about 35% of our trial judges are women. We have almost no judges of color, almost no clerk magistrates of color. That's a problem. I want to shine a light on that. That problem's not going to be solved overnight, but we've got to push on that. And one of the ways I'm going to push and advocate pushing is to say to the governor, hey, if we get more of the same, a third or fourth more of the same, we're not going to approve the next appointment. We're just going to hold it up. That will get the governor's attention. The media will be on that story. What's going on? Oh, lack of diversity? Why isn't the governor addressing that? And I assure you, then there will be alarm bells going off and problems being solved.
Thank you very much. So we arrive at closing statements very quickly, as always. I'll just remind you that you have 2 minutes for your closing statements, and then we'll do those in reverse order from the opens. So Mrs. Devaney, you go first.
Okay, thank you very much. As a daughter of Italian immigrants, I know discrimination, and I look for diversity and for women in judicial positions. My opponent lies and says specious allegations about me and my proud record. He has raised over $180,000, largely from lawyers who want to be judges. He has already bought and paid for. He wants to be a senator. I only want to stay as your governor's counselor. He started out campaigning against Senator Cream and got discouraged and looked at the governor's council as a second choice. With 32 towns and cities, the odds were better. Governor's council is too important to be a stepping stone. I have a committed record of being there, available to go out into the district and talk with people, and I have 100% attendance. I'm not a lawyer, not doing lawyer's work, and as I said, a lawyer by law can appear before judges they vote on. I'm not looking for financial gain. I just want to continue to use my experience to serve you. When I started, I made $14,000. I knew it was an important position because it affects you or someone in your family, everyone I vote on. I have never let you down, and I ask for your support on September 4th to continue to work for you. Thank you so much. I appreciate it.
Thank you. Mr. Carter.
I'm Nick Carter. I'm running for Governor's Council. I'm a 25-year trial attorney. People who know me know I'm not in this for the money. I'm not in this to help friends become judges. When Donald Trump was elected, my kids were grown. I said, if I can't get into this fight, who can? I've got an obligation, and for 1 year, I've been fighting to get my name known and to win this office because I care about our courts and our values, and I'm gonna fight for them. Now, one thing, and I say this respectfully because the incumbent has served for 20 years, but she has undermined our judiciary. She has joined Trump Republicans in calling for the impeachment of Tim Feely, joining people like Jeff Deal, Howie Carr, because she thought and they think that he was soft on crime in a case. That undermines our judiciary, which is supposed to be independent, not politicized. And in the process, she said, and this is all on tape, I want to ensure the legislature changes our sentencing guidelines to make sure this doesn't happen. Well, that means mandatory minimums, tie the judge's hands. That is the wrong direction. Now, people know it's time for a change. Let me just tell you, the last 3 Massachusetts attorneys general have endorsed me: Martha Coakley, Tom Riley, Scott Harshbarger. The last 4 Middlesex County District Attorneys have endorsed me. I'm very proud to have the endorsement of State Senator Cindy Friedman. I'm very proud to have gotten to know many in Arlington, and every single select board member in the Arlington Select Board has endorsed me. 6 of the 7 school committee members in Arlington have endorsed me. I have the Sierra Club's endorsement, multiple Democratic town committees' endorsements. I say this not to brag, but because I'm a first-time candidate running against a 20-year incumbent, and I'm getting this kind of support. It's time for a change. Please vote for me and spread the word on September 4th. Thank you.
Thank you, and thank you both to the candidates for governors.
I have no rebuttal about this.
No, I'm afraid not.
Well, I have Congressman Capuano, Congressman Lynch, Congressman McGovern.
Thank you very much. Thank you very much to both of the candidates. We will now be moving on to the Middlesex District Attorney's debate. And yes, feel free to applaud.
Thank you. We will now begin the district attorney candidates. Better? Thank you for your guidance. I'm Patty Muldoon. We are now beginning the district attorney candidates debates. The district attorney is the lead prosecutor for our county. The DA supervises assistant district attorneys, also known as ADAs, or prosecutors. The debate that we have for you tonight comes in 3 parts. Each has a different opening, and then we will have an opening at the beginning and a closing at the end. So we will begin with opening statements. We flipped a coin, and Donna Padalano will begin.
Thank you so much. I'd like to thank the League of Women Voters, the ACLU, the Mass Incarceration Working Group. Thank you, Marion, for coming to the debate today. I'm excited about sharing my vision for the Middlesex DA's office. I didn't go to law school until I was in my 30s. We have a broken criminal justice system. I'm running to fix it. I went to law school after a career in healthcare management. I went on to work as a prosecutor. I wanted to make a difference. I worked as a defense attorney. I made that difference. In fact, the Supreme Judicial Court appointed me chair of the Board of Bar Overseers, the agency that oversees the integrity of my profession, the 60,000 active attorneys in Massachusetts. We need transformative and transparent change in Middlesex. I have the experience, I have the vision, and I have the courage to do that work. The criminal justice system is infected with racial and economic disparities. It operates in a black hole.
Thank you. And Marion Ryan, please, your opening.
Thank you. And I echo the thanks to everyone who made tonight possible. I am in this race the proven progressive. And I'm going to give you 6 examples from my first term of the work that I've done on the issues that we all care about. I very early on separated from the other district attorneys in supporting a change in mandatory minimum sentences. I then went on to support the very progressive Senate criminal justice bill. Meanwhile, in my own office, unilaterally, we ended the practice of asking for cash bail on low-level nonviolent offenses, and I've also faced down another law enforcement agency, in this case ICE, to end the culture of fear in our courtrooms. I am a vocal champion for restorative justice. I helped to write that legislation, and I'm continuing my work on conviction integrity by co-chairing with Attorney General Maura Healey the Mass Bar Commission on Conviction Integrity. A vote for me means a proven progressive in this role. Thank you.
Thank you. And moving into the first set of questions for our candidates, each of them will have 2 minutes to respond to some complicated questions, and then 30 seconds to rebut each other's. We encourage you if you don't need to rebut, let's move on, because we do have a lot of questions, but if you do, you'll both have that time. And we will, of course, be alternating who's responding first. We have timekeepers in the front. You will get a notice for 20 seconds during the 2-minute review as a warning, and then the stop card. Please do keep your eye on our timekeepers. Beginning with Donna Padalano. Middlesex County's pretrial incarceration rate nearly quadrupled from 2011 to 2015, according to the Vera Institute. This sharp increase did not occur in other counties. How do you explain this? And what would you do to lower pretrial incarceration rates?
So it's not just that the pretrial incarceration has nearly quadrupled. Really, what's also happened is we are incarcerating 8 times as many Black people and 5 times as many Hispanic people here in Massachusetts. We are complacent liberals. We need to elect, you need to elect a district attorney who is willing to address the problem of mass incarceration in a way that's never happened before in Massachusetts. When people are held pre-trial, they lose their jobs, right? They lose their apartments. If they have custody of their children, they lose their children. And I've talked to Sheriff Katusian. He will tell you if they are held pre-trial and they are innocent, presumed innocent people, they are held pre-trial, they get no treatment when in there. The Chapter 55 report just came out of the legislature that said folks who are released from incarceration are 120 times more likely to die from a fatal overdose. This needs to stop. First, I will have a bail policy that isn't just a press release. I will have prosecutors in my office trained so that there will not be cash bail. The presumption is no cash bail. We should not be incarcerating folks who are too poor. We have a debtor's prison now. No cash bail unless it's a violent offense as defined by Chapter 265. I will also release the data at least every 6 months about every bail request we make and what the outcomes are. Also, our prosecutors will be trained to tell the judge what the cost of incarceration is. Under this year's fiscal budget, it's $265 a day. If somebody can't afford $500 bail, does it make sense for the taxpayers to pay $265 a day to incarcerate that person? We need better outcomes, and part of that is by getting the data so that we have transparency and we know what's happening in the courtrooms in Middlesex County.
Thank you. Marion Ryan.
We have, as I mentioned, abolished the practice of asking for cash bail on low-level, nonviolent offenses, so we aren't doing that. And how do we see that result? We've seen that result in a dramatic decrease in our numbers in the jail. And we used to have a practice where at the end of the day, the jail would be so overcrowded that we would essentially have to have prosecutors and defense attorneys meeting with judges to decide who was being released. Our numbers are so low now that that's no longer happening. That is in part due to the practice of not asking for cash bail on a number of offenses. It's also due to the diversionary options that are present for so many other folks.
Ms. Padalano, rebut.
I did a public records request of the Middlesex District Attorney's Office, and there was absolutely no data specific to the cash bail program that my opponent talks about.
So that data comes from the Sheriff's Office because they are responsible, obviously, for the counting and keeping track of how many folks they have. That number, when it dropped to a certain level, as I said, led to the end of the late-day jail release call. We no longer do that because our numbers have dropped to such an extent.
Moving on, and I want to remind the audience to please just raise your hand if at any point any of us are not using our handheld mics. Thank you. Beginning with you, Ms. Ryan. In cases involving possible family violence, how do you think the ADAs, the Assistant District Attorneys, should balance the presumption of innocence with the safety of family members when deciding whether to try to have someone held pre-trial? Should ADAs request a dangerousness hearing for every individual who's been accused of family violence?
Certainly not, and many of those offenses are not offenses that we would be looking for a dangerousness hearing on. It is a question of assessing what's the outcome going to be in this case. You don't hold people on bail when the likelihood is the case is going to resolve without them getting a jail sentence. So that's one piece. Then the other question is, how do we make sure that people are safe in the meantime? We have a lot more tools about doing that. We have GPS bracelets. We have lots of other orders and things that can be put in place to make certain that people are safe. And another important factor, and something that all of our ADAs are trained on, is cultural competency. It's really having those conversations with our victims about what does this mean for their family, what is it that they would like to see happen. We are listening to what victims are telling us about what they'd like to see happening, and we are using the least restrictive alternative to make sure that people are safe, and to the extent possible, the accused is able to go back to their life.
Ms. Padalano.
Part of what we need to do, and is not happening now in the Middlesex DA's office, is use the Victim Witness Fund. This is a fund that the legislature has that in the last 4 years, there have been 140,000 cases in Middlesex County. It's been funded to the tune of $650,000. Middlesex County, under the incumbent, my opponent, has filed 2 claims for a total of $3,800. $650,000 available for victims, $3,800 used. This is money for a victim of domestic violence that we can use to help them move or to change their locks, because a piece of paper like a restraining order is not going to keep them safe. We have very few resources, and if we're not using all of them for the most vulnerable people in the society, we are missing an absolutely huge opportunity.
So that speaks to some confusion. There are actually 2 victim witness funds, one of which we use frequently to help witnesses be reimbursed for any number of expenses they may occur, medical expenses that aren't covered, co-pays, all of that sort of thing. The second fund, which I believe we're discussing now, is a witness relocation fund. That is a fund that is available for witnesses who need to be relocated, who need moving expenses. It is also a fund that is difficult for victims because it requires that they agree not to disclose where they are. There's a very long contract that they sign, many of whom, particularly in our climate today, are unwilling to provide the kind of information necessary to the government to sign that. So we rely primarily on the other fund.
Thank you.
I will say in Suffolk County, where I was head of training, 1 year our claims went down on that fund $22,000 in 1 year. I put together a training program, taught the prosecutors how to use it, and the next year we had $88,000 worth of claims. That's the difference a leader makes who is looking out for the most vulnerable people in the criminal justice system who are there through no fault of their own.
Moving on to a question about restorative justice. Restorative justice asks multiple parties to work together to figure out how to promote healing for victims and communities, responsibility for offenders, and restoration of trust. Ms. Padalano, what do you think is the ideal role of restorative justice in the legal system? And how close is Middlesex County to that ideal?
Restorative justice is critically important in Middlesex County, as it is in all the counties in Massachusetts. Many times, when you're working with victims, really what they want is an apology and to know that the person is on the right track, and that's part of what restorative justice does. One of the problems with restorative justice in Middlesex County right now is we have no idea who gets restorative justice. I was in the Woburn District Court this morning, and I talked to a defense attorney, and I said, how are the programs going? And she pointed to always white people who are using restorative justice. Used great here in Arlington, in Bedford, very robust program. What's going on in the rest of Middlesex County? Do you have to be a white person to get restorative justice? Can I tell you that? No, because the data on restorative justice, who gets it, who gets to access it? Is it the person with the private counsel or the person with public defender? Is it the kid from Everett or the kid in Ashland? I can't tell you that because we can't hold my opponent accountable because none of that information is released, as well as none of the information about the outcomes. If we're going to invest in these programs, we need to make sure they work, and they do work. So let's make sure that we get that to all of the people in Middlesex County.
Ms. Ryan?
Middlesex County right now is the statewide leader in restorative justice. I alone among the district attorneys have embraced these programs. We use them across our county, not only in our courts, but in our schools. Lowell actually leads our schools in terms of the available programs regarding restorative justice. So we have not only led here, but I helped to write the legislation that's contained in the new criminal justice bill. We really are going to be the example as other counties begin to use these programs. The question is, are we using these programs? Are they across this county? And the answer to that question is a resounding yes. And I'm very excited about the fact that the new criminal justice bill will now allow, well, the people we know have not been able to take advantage of them have been people in other counties because they haven't had the option of having them. It is with this new bill, which with the support of Senator Brownsberger, Senator Eldridge, Representative Garbely, we were able to incorporate this into the bill and make them available. Now we do know that everyone across the state will have the option because the court must offer those as potential dispositions.
If we're incarcerating 8 times as many Black people and 5 times as many Hispanic people, something is going wrong in the courtrooms of Middlesex County. Something needs to change. And the only way we can do that is by looking at the data and making sure there is equitable use of these programs. You can bet if my opponent had the data, she'd bring it to the debate.
Ms. Ryan, what have you learned about how to prevent false convictions or identify incarcerated people who are actually innocent?
One of the things I most wanted to do upon becoming district attorney was to bring a conviction integrity unit to Middlesex. And I did that very soon after I became district attorney. Having studied the programs across the country, beginning with the first program, which was in 2006 in Dallas, and a number of other programs, including at the Suffolk County DA's office. And then we built a program. That program has continued to operate. We, in fact, brought forward the conviction, which was brought to us by the defendant and his lawyer, which was recently the subject of a debate about whether or not the person who'd been exonerated was entitled to funds. And there was a trial about that issue. That detective who brought that case forward will be receiving an award at the Innocence Project training, which I'll be participating in training in a couple of weeks. And as I mentioned, I'm delighted that I, along with the Attorney General, will be co-chairing the Mass Bar Association's Conviction Integrity Committee with a goal of 2 things: putting in place safeguards that will prevent wrongful convictions, and secondly, making Massachusetts, to our knowledge, the first state in the country to have conviction integrity available in all district attorneys' offices.
Thank you.
And while I worked at Suffolk County, I told you I had worked as a prosecutor and as a defense attorney. After I worked as a defense attorney, I came back to Suffolk County to build the first conviction integrity program in the Commonwealth. It is incredibly important that it's a collaborative process and that we provide open file discovery to the defendants. We asked them to come to us first before they even went to court, because if they're spending one day in jail as an innocent person, that is one day too long. The last case I worked on before I left to campaign for this office was a man who had been wrongfully incarcerated for 38 years based on 2 eyewitnesses who had been hypnotized before they looked at photo arrays. I know this work, this is my life's work, and I'm looking forward to making a robust program in Middlesex County.
Rebut?
The supplement to our program is we put together really a first of its kind, I think, working group where we have had the State Crime Lab join us, the Innocence Project, the DA's office, and Committee for Public Counsel. That's not a group you usually see working together. We've been recognized for the last 3, we're going into the 4th cycle with Department of Justice grants for the collaborative nature of that work. We regularly, with the Innocence Project attorneys, train defense attorneys at how to bring these claims forward. How can we give them access to the evidence? If someone is in jail and they should not be there, one day waiting is too long.
What my opponent forgets is the very first Department of Justice grant that was applied for was at the Suffolk County DA's office with the public defenders and with the Innocence Project, and we then invited Middlesex County to come on board.
Thank you. Ms. Padalano, what would you do to improve how Middlesex County handles juvenile offenders?
There's been science now about brain development, about the cognitive development of young adults. It's important that we take advantage of their ability to be rehabilitated. Just like they have just like they're sometimes impulsive, they also are able to be rehabilitated. I have a proposal, it's on my website, donna4da.com, for a juvenile and emerging adult bureau. It's so that because the legislature did not raise the age of juvenile court jurisdiction, that we can treat cases of those 24 years and younger and screen those first to see what programs would be useful, what would make successful outcomes, so that we can take these young adults out of the criminal justice system. We also need to make sure that the programs work and that this is provided to everybody in Middlesex County. Right now, I know I'm going to sound like a broken record, but we don't know what juveniles are getting diverted. We don't know what juveniles are given the opportunity to be part of programming, substance abuse treatment, mental health treatment, work training programs. Who gets that? I can't tell you. You can't hold the opponent accountable. I'm running to be DA because I think we should shine a bright light on what's happening in all of the programs in Middlesex County and make sure that we are equitable to all of the folks across our community.
Ms. Ryan?
Anybody who's ever known a young person or raised a child knows the truth of this brain science. It's important that we be treating these young people differently. I was honored last year to be asked as one of Massachusetts criminal justice leaders to go to Germany and study the work that they've been doing there for the last 50 years in this area. I brought that back to our Young Adults Bureau. We have broadened the definition of young adults. We aren't holding people to their birthday so that something, if they turn 24 or 25 yesterday, they can't come into the program. We've broadened our definition of the offenses that we will consider. We've broadened our considerations about whether someone has a record or not. What I can tell you about our diversion programs is that we've had a 56% increase in the number of people going to diversion from 2012 to 2017. And the success rate of the folks in those diversion programs for last year stands at 72%, and the recidivism rate for 2016, which obviously is the last year we know, in 1 year 1 year after completing that program, the recidivism rate stands at only 6%. So I know those programs are working. I've learned a great deal about those programs. We have a Young Adults Bureau. We are making that available across the county, and we see that it is working. There's no question about that.
It is true that diversion programs work, screening programs work. This is the first time that we've heard this data, so I'm glad to see that our campaign is already doing some good, but we need to have meaningful data. How do you define success? I can't tell you. We need to know this because it's too important. We can stop kids from being involved in the criminal justice system, but not until we understand what's happening in the courtrooms in Middlesex County.
You know, let's be honest. The reason we want to see data is because we believe that data will confirm what I know and what so many of you know. There are racial disparities in our criminal justice system. There is no question about that. I can save us some time and money. I've accepted that premise. And I've accepted my responsibility as district attorney to be doing something about it. Leadership is about action. I've taken those actions. I've grown our diversion programs. I've halted the practice of cash bail for a number of offenses, and I'm supporting meaningful change in terms of the opportunities we are offering to people in the criminal justice system. Thank you.
Thank you. So that was about juvenile justice. Now we're moving to young adults. Beginning with Ms. Ryan, what would you do to improve how Middlesex County handles young adults who are arrested between the ages of 18 and 25?
We have created that Young Adults Bureau. We are constantly partnering. One of the partnerships we're working on right now is with a trade organization, because you know what? When people get through with the criminal justice system, if they don't have a job, if they can't get a place to live and they can't support themselves, they're very likely to repeat what happened. So we're working on the jobs piece of that. We are working on things like restorative justice that really give folks a transformative experience, that opportunity to really reflect on where they are to make a change. Our goal is to change the trajectory of someone's life. I have been a prosecutor long enough, unfortunately, to prosecute the children and sometimes even the grandchildren of people I previously prosecuted. That is a broken system. That's why we are putting so many guidelines, so many opportunities in place for young adults to be able to recover from something. We have a pre-arraignment diversion program so that people can get drug treatment if that's the issue without having a criminal record. We are working very hard about not only mental health, but the dual diagnosis. The number of people with dual diagnosis and substance issues is enormous. We are working and putting in place those programs to change the trajectory of people's lives.
Thank you. Ms. Padalano.
Part of doing this work is making sure that the prosecutors are able to assess a case in an appropriate way. Many of these prosecutors right out of law school are within years of these young adults who they are now handling the cases and prosecuting. Part of what I did when I was head of training at the Suffolk County DA's office was to make sure that all of the 150 prosecutors in our office were trained on the brain science, because I know how that works. I have 2 sons who are now adults. I live with teenage boys in my house. But these young prosecutors don't understand that, and they need to know how come kids might be in the system, what the context is of the incident of getting them there, and how best we can get good outcomes. And then our office needs to make sure that we're releasing those outcomes to you so you can hold me accountable as your Middlesex DA's office, and we're investing money in programs that actually work.
I also had the privilege of being the director of training, and part of doing this work is knowing who you are. I am a white female prosecutor. I can't talk about life experience and what has happened to people in terms of being incarcerated or not having opportunities. So part of our training comes not just from experts in brain science, it comes from the formerly incarcerated folks that we bring in to talk to people. We take our young prosecutors on tours of the facilities to which they might be making a recommendation, and they really hear from people what their life has been like.
I'll pass.
Pass. Great. Moving on to another topic. People who are on probation or parole can be incarcerated just for drug use or missed appointments, And frequent appointments and electronic monitors can interfere with their ability to hold a job or take care of children. Would you ask your ADAs to request probation and parole conditions that require less monitoring and don't penalize individuals with substance use disorders for lapses into drug use, and instead focus on avoiding criminal activities that hurt other people? Why or why not? Ms. Padalano.
The conditions that are part of parole and probation can be onerous. All you have to do is go sit in the courts, and you can see somebody who comes in for a 9 o'clock hearing. I was there this morning, and the hearing didn't happen until 11:30. These are people who are trying to keep jobs, and they're missing their work because of these hearings. We need to figure out a way to work with the trial court so that we can make it more efficient, so that people who are released and trying to become meaningful and productive members of society can actually do that. We need to make sure that they have the right substance abuse treatment, that they have the right mental health treatment. If we can't do that, we're setting these folks up for failure. That is the end of the story. So part of it has to be working with the trial court, whether it's through a text message system in the way that we do for when you're on jury duty, to make sure that they have a limited window when they come to the court so that they can be effective when they come in and they can keep their jobs. That's part of what we need to do. We need to innovate with the trial courts and make sure that folks are able to keep their jobs once they're released. It also is part of making sure, I think, that the SJC just came down with a case, the Supreme Judicial Court, that said that we can put as a condition of probation that people stay sober. That's wrong. It's hard to get sober. I've had clients as a defense attorney who tried to do that. Let's make the condition treatment. Let's try and get these people to be sober and clean. Let's use the drug court for everybody in the community. Who gets access to the drug court? Guess what? I can't tell you, because my opponent doesn't release that information. So let's make sure we're equitable to everybody in the community, and that we think about keeping people in society and working and productive.
There's no question, anyone who knows about addiction knows that lapses are a part of getting to a place of sobriety. So we have to be able to incorporate that. That's when, for instance, when we offer people diversion and treatment programs, we do not engage in what happens in terms of whether they're being kept in the program. We leave that to the program, the experts in treatment who know how to deal with that. We offer, for instance, a 16-week program. We don't care if it takes you 30 weeks to commit to finish that program. We want you to get the treatment. We're not interested in having the program call and tell us that you've had a lapse or something's happened. We want them to do what's best for you to move you through treatment. We've been engaged in conversations with the Commissioner of Probation about ways to make probation hearings work better. We used to have Saturday court. Saturday court would perhaps be a good option if we could figure out how to do that for folks who could come in on Saturday mornings and have their appointments. Drug court really right now, and the way that the Commonwealth's able to fund that, and the Commonwealth, the trial court, by the way, does keep very good statistics about who's in the drug court, but that is reserved for high risk, high need. I thought that seemed silly that we would wait till someone was high risk, high need. That's why we've created a number of lower level diversion programs that can address people earlier in their addiction. Let us use the resources of the drug court as they've been set up by the trial court for those very deep in their addiction. Certainly try to move the trajectory of people's lives sooner rather than later.
The trial court does not publish those statistics on their website, and they're not subject to public records law. So maybe the opponent gets to see the great statistics on drug courts, but you don't, and I don't, and we can't hold her accountable. If we're investing hundreds of millions of dollars in the criminal justice system, we need to make sure that we're doing the right thing, that we're getting the right outcomes. That's why getting the information is so important, because without that information, we'll never know why we have the inequities in the system.
So we talk about data, and we talk about the fact that what's clear is that one thing all of the district attorneys agree upon is it would be better if we had more data, because no one has some of this data. Nobody is able to access it with the hardware and the computer work that we have. The cost for doing a statewide replacement for that is estimated to be about $16 million. So what are the alternatives? I've done a number of things. I've entered into a long-term study with Northeastern University, giving them unprecedented access to our files to be able to actually pull out the information that will give us a lot of the data that we don't have. I've partnered with the American Institute for Research to do a similar type of data grab.
So moving on to yet another meaty topic, and beginning with you, Ms. Ryan. When a district attorney is deciding whether to oppose a petition for parole, should she start with the presumption that an individual who is eligible will receive parole unless there are reasons to keep them incarcerated, or with the opposite presumption that an individual who is eligible should continue to be incarcerated unless there are reasons to parole them? And how much should the preference of a victim or their family affect parole decisions?
This is a question to which I bring several perspectives. One is as someone who's been a prosecutor for a long time, who has appeared any number of times at the Parole Board, but also as someone who, as a young lawyer, was myself the victim of an extraordinarily violent armed robbery that resulted in the murder in front of me of my then boyfriend. 3 individuals were apprehended, they went to jail, and I've testified as a victim at those parole hearings. So I know well the stakes and the needs of victims that they bring to those, and I know well that despite what victims may sometimes think, the outcome of the Parole Board doesn't bring back the person they've lost, and it doesn't fix what happened to their lives. Making that decision to oppose or support parole, which the district attorney has an opportunity to do in some cases, involves the consideration of a number of things. It involves the facts of the incident that occurred. It involves the consideration of the role that this defendant played. It involves the consideration of the path that individual has taken since then. What have they availed themselves of? What has their conduct been inside? It does involve a consideration of the views of a family or a victim. It also involves a consideration of the public safety. Can we all be safe? Are there conditions that on parole we could be safe? And it is in that balance, that very difficult balance, that we often find ourselves asking for certain conditions, asking for more time for somebody to have finished a treatment program, or sometimes supporting a petition for parole. But I bring a unique perspective to that.
I've been fortunate to appear before the Parole Board any number of times, and sometimes what the victim says is, "We forgive." One of the most powerful moments in my career was when the victim's family got up and said, "We forgive," and that person was paroled. So sometimes the victim's opinion is extremely important to take into consideration. Whether it is for forgiveness or vengeance, that's one piece of the puzzle that we put together. In my office, prosecutors who appear before the Parole Board will be presumed to ask for parole. If they do not ask for parole, they will identify the reasons specific to that candidate why they are not asking for parole, and it will be documented and presented to the Parole Board. I did appear in opposition of that person who was then forgiven by his victim's family, and right there on the spot said, if they can show that kind of grace, then we can't possibly oppose the parole, and we can find a meaningful way to get this person back out and be a good citizen in our society because their debt had been paid.
One of the things that is a really important, one of the other important factors in assessing whether or not someone should be granted parole is the viability of the plan they have for what they're going to do when they get out. Do they have a place to live? Do they going to have some kind of job? What kind of supports are they going to have? And that is something that we don't always do well, putting in place those supports. I've signed on to the Columbia University Justice Lab statement on post-release supports because we need to be doing much, much more in this state. of putting in place ways for people to recover from having been incarcerated with a likelihood of success. We should not be releasing people just to watch them fail and end up with a violation of parole.
In my cases, the Parole Board did an excellent job on getting an exit strategy for these people who are paroled. One of the big holes to fill are those people who are exonerated, because they actually get no services when they are released. And that's something that needs to change and something I will advocate for.
Moving on to our last two questions of this section. Donna Padalano, what steps have you taken to help identify and reduce racial disparities in prosecution, sentencing, and incarceration?
When I was at the Suffolk County DA's office, as I said, I created the Conviction Integrity Program. We also did something that I call prospective conviction integrity. So it was something that I had read about in a law review article. We wanted to improve the culture in the office to make sure that prosecutors were looking at their mistakes. So one of the ways, we're all human beings in the criminal justice system. Mistakes are going to happen. So we defined what we meant by mistakes. They were suppression orders and dismissal orders. We looked at those. We tracked the information by judge, by prosecutor, by court, by type of crime. And then when we saw patterns develop, we put in place training programs or policies to address the issues that we saw coming up. And it might have been that we had a prosecutor that needed to be reassigned, or maybe even fired, or that we had to have a tough conversation with our law enforcement partners because they were doing something that was unconstitutional. But unless you're looking at your mistakes and you have a culture in the office where you're asking people to comply, a compliance office in a prosecutor's office, this isn't happening anywhere else in the country. And this is something that I want to bring to Middlesex County, because it was meaningful that folks understood that when cases were dismissed or evidence was suppressed, that we weren't just going to hide those away. We were going to look at what happened and improve what happened in the court the next day.
Marion Ryan, what steps have you taken to help identify and reduce racial disparities?
Beginning from the premise that we know there are racial disparities in our system, you have to start, as you start with so many things, by looking at yourself. And we know that we all suffer from biases, implicit or not. So one of the first things I've done is to bring to our office Judge Bennett, a federal judge who's a nationally recognized expert on implicit bias, who came to train the members of our staff, trained the members of our law enforcement community on how to examine yourself, how to be thinking about what are my biases. The second piece is, having seen the impact of that in folks with respect to bail, we discontinued the practice of asking for cash bail. We then discovered that another piece, and we don't always think about this, we like to think that forensic evidence is a touchstone. It's so much more reliable. Well, there's actually a lot of research that shows that bias impacts us in terms of forensic evidence. So we have on several occasions, again, partnering with the Innocence Project, brought one of the world-renowned experts here from the United Kingdom to train both our DAs, to train our law enforcement partners and our labs on implicit bias as it impacts forensic evidence.
Rebut?
I will say that one of the implicit bias training is a given in every single office, that you're missing an opportunity if you don't do that. But what we need to do is also look at explicit bias. We're not doing that now, and that needs to happen.
Rebut?
Nothing.
Okay. Last question of this section. Thank you, everyone, for hanging in there. Last question for this section. Thank you. Marion Ryan, what types of transparency and data sharing do you think would best enable the public to evaluate whether the DA's office is doing its job well?
Well, as I mentioned, we all agree that more data would be better. There are two routes to take with that. One is, can we get the data? As I began to mention, I've done this partnership with Northeastern University to be able to give them access to our files to collect that data. I've partnered with the American Institutes of Research, one of the national in the forefront of that kind of research, to track our efforts. I just a couple of weeks ago had the opportunity to go to Washington to testify for Senate staffers about the way we've been using our data to help us really impact the opioid crisis, how we have been able to achieve much higher than the rest of the state, an 11.5% decline in fatal overdoses here in Middlesex County, and up in Lowell, where we were hardest hit, where I have spent countless hours, we were hardest hit by the opioid epidemic, a 21% decline in fatal overdoses. So that's one way that we've been able to gather data and track that. We have continued to look at what is that data, how can we make it more transparent and more available. Much of it what is already available, and then the other piece is what I talked about earlier. If we want the data to show us that the system has racial disparities, I agree that that is true. And what I hope is that as we get this data, we will see not only that there are what we anticipate there will be, these disparities, but we will see that the actions, because the action's important, the actions we've been taking to address these disparities are starting to mitigate some of that harm.
Donna Padalano.
We should all applaud our first responders and how they're able to effectively use Narcan to reduce the number of fatal overdoses in Middlesex County. That is a true win. But let's focus on what the district attorney has complete control over, the courtroom. What do we know about what's happening in the courtroom? How do we know what's happening in the Malden District Court is the same as what's happening in the Woburn District Court, as is what's happening in the Framingham District Court? Even for the good people who work in the Middlesex County DA's office, their hands are tied, because when they're trying to resolve cases in a district court and they don't know what an equitable resolution looks like in the other district courts, then they can't possibly be fair and equitable. Again, if we are incarcerating 8 times as many black people, something is going wrong. We just can't say something's wrong. We need to know specifically what's going wrong, because until we do, we can't possibly address those issues. I know I sound like a broken record. I promise you, I am not a one-issue candidate. But what I will say is this day and age, our justice system is the moral backbone of our government. And if it functions like a black hole, then how can we know that what we're doing is fair and just?
Having a county as large as Middlesex, we certainly do need to know what's happening across the county. That is why we have in our district courts several layers of supervisors, many of whom are on the ground in the courtrooms. They're looking at what's happening. They're talking to those young lawyers, because we don't do a cookie-cutter approach in Middlesex County. We don't just count the numbers. We have people who talk to people and look at cases and decide what's a fair and equitable resolution. And then those regional supervisors are able to talk amongst themselves to determine what's happening across our county.
When the turnover rate in Middlesex County is the highest in all of the Commonwealth, 15% of the experienced prosecutors leaving every year, talking among the staff is simply not enough. We can't hold the office accountable unless we know what is happening in the courtroom and that the prosecutors are trained appropriately across the board, not just through conversations.
Thank you both. We front-loaded some of the harder, more complicated questions so that we'd get everybody's attention. And on this hot evening, I thank our whole audience. Please don't applaud. We're moving straight through into yes/no questions. So we're going to begin the first series of questions. Donna Padalano will answer first, and then, of course, we'll switch. All right. So very briefly, both of you say you oppose the use of cash bail for low-level offenses. Have you or will you create a list of specific low-level charges for which ADAs are instructed not to ask for cash bail?
Yes.
Marion Ryan?
No.
Clear? If yes, will you release this list of no-bail offenses to the public?
Yes.
It's important that we look at offenses individually. An offense, for instance, trespassing, very low-level offense. If I'm trespassing in the place of work, that's a problem.
I know it's unfair.
Okay, sorry.
They are yes/nos, and
That's
there's
fine.
a lot to say about them all.
Okay.
Will you release data every 6 months about how many people have been held pre-trial in Middlesex County and how long they're held? Yes,
Yes.
no?
Yes.
Thank you. Do you agree with Massachusetts Sentencing Commission's recommendations to abolish mandatory minimums for all crimes except murder?
Yes.
No, there are certain aggravated repeat offenses. Sorry.
I know, it's hard. People's assets, including houses, cars, and cash, can be seized and forfeited even if the property owner has not yet been convicted of a crime. Do you believe assets should be forfeited only if the property owner is convicted? Yes, no.
Yes, that will happen the first day I'm elected.
Yes, we move forward on conviction.
Okay, let's get back to our discipline of yes, no.
Sorry.
Will you annually release data to the public on the collection and use of asset forfeitures?
Yes.
Yes, no.
Yes.
Well done.
Can I just say it's required by statute now, so it's an easy answer.
Okay, I know it's really, really hard, particularly for attorneys. Beginning with Marion Ryan. The next 3 questions are about restorative justice eligibility. The next 3 questions are about restorative justice eligibility. Would you allow people who are not first offenders to participate in restorative justice?
Yes.
Yes.
Should adults of any age be eligible for restorative justice?
Yes.
Yes.
Should pre-arraignment restorative justice be available in every municipality in Middlesex County?
Yes.
Yes.
There you have it. Moving on, continuing with Marion Ryan first. This one is technical. Will you adopt and enforce a policy of open file presumptive discovery in felony cases, going beyond the Brady Court decision that required only exculpatory evidence to be shared with the defense?
Of course.
Yes.
Do you think that incarcerated people who are eligible for medical release under the new legislation, people who are either terminally ill or permanently incapacitated, should receive it unless there are special circumstances?
Yes.
Yes.
And finally, will you create a community advisory board that includes both formerly incarcerated people and former victims and engage with this board?
Yes.
Yes.
Thank you. You are doing great, not applauding. So we're moving on to our final round of Jeopardy! This one is 90 seconds per candidate, no rebuttals. So, beginning with Donna Padalano, both of you have experience doing defense work, either as a law student or as an attorney. How have these defense experiences affected your work as a prosecutor?
It was a transformative experience for me. When I represented people who don't look like me, it opened my eyes in the way that has changed my life. When I first was a prosecutor, I thought that I had to prosecute every case that came across my desk. I really thought that. And you know, when I started to build relationships of trust with my clients, people who felt like they had either been let down by the system or let down by their trial attorney, and sometimes both, I couldn't disagree because most times they had been. Part of those experiences were the reason why I went back to the Suffolk County DA's office to build the Conviction Integrity Unit, to use my experience visiting my clients who are incarcerated, not just visiting to see how they live, but visiting because I was representing them because they could not afford an attorney of their own, and fighting for their constitutional rights. Taking that defense experience and having a compliance officer in Suffolk County, making sure that we had a culture where we were always looking at mistakes, where we weren't just trying to get a conviction at any cost, where we were working in the furtherance of justice, that changed my career and that changed the culture of my office. It's critically important that we continue to hire folks who have had defense experience, especially for the Conviction Integrity Program, and that's something that I am committed to doing.
Thank you.
I had the opportunity to represent folks in the Dorchester District Court before I became a prosecutor, and it humanized people. in a way that does change you, and you bring that to your work. It was an opportunity to really come to understand how hard it was sometimes even just to get to court, how much money it cost to get there, what you had to do for childcare, and really how many opportunities had probably been missed with folks who were in the courtroom at other places where their lives might have been different. So I have been a better and a different prosecutor because of that experience.
Thank you. And beginning with Marion Ryan. How have you engaged with formerly incarcerated people, either individuals or organizations? And how have these conversations affected your attitudes and policies?
It is much the same as representing someone. I think every time, for all of us, whenever you engage with people who are different from you or have a different life experience, you grow and you learn. Formerly incarcerated people play a very important role in our office. As I indicated, they are part of our trainings for our new DAs. They come in and talk to great length with our young DAs. I also organized a policy forum, a mobile policy forum, which I took around the county, where folks who had been formerly incarcerated on drug offenses came with me, talked to members of the community. I think we actually did one right in this room, talked to members of the community about how they had gotten to that place in their life, what had been helpful for them, and really, again, help to humanize that piece. We are very involved with organizations like UTEC and ROCA, so many other programs that really bring to work and put to work and change the lives of people who've been formerly incarcerated.
Thank you.
There's a difference between doing an internship as a law student and working as a defense attorney for many years. I've represented defendants in the Superior Court, in the Appeals Court, and in the Supreme Judicial Court, the highest court in Massachusetts. The very first case that I had in the Supreme Judicial Court with one of my defendants ended up getting him his conviction vacated. I have seen the power of getting a record sealed because my client couldn't teach Sunday school because she had a felony conviction. It's not until you know those experiences. She couldn't even take her kids on a field trip because she had a felony conviction. When we got her record sealed, her life changed. You can't go through those kinds of experiences without it changing the way that you look at every single case that you're dealing with. And that's the kind of mission that I will take to the Middlesex DA's office to make sure that we're working in the furtherance of justice and not just working to affirm a conviction.
And staying with you, how would you increase the hiring and retention of ADAs who are people of color or come from lower income neighborhoods?
This is near and dear to my heart. One of the things I think that is critically important about this, no surprise, is data. I will release from the Middlesex County DA's office who applies to the office. Typically, we'll get 500 applications in the Suffolk County DA's office from young people who want to be prosecutors. Let me tell you what their gender is, what their ethnicity is, what color their skin is, what communities they come from, what schools they went to. That information will be released. But then we'll release the second round interviews. Who made it to the second round? Not their personal identifying information, but what does that class look like? And who got final interviews? Because I want to have a community, a courthouse that represents the community. I was talking to some folks in the Brazilian community in Framingham just recently. There's no one who speaks their language in that court. And they feel scared to go in anyway because many of them are not documented. We need to make sure that the people in the courthouse represent the communities that they're prosecuting. And the only way you can hold me accountable by that is to see what kind of recruiting we're doing and who's applying to the office and who we're hiring.
Thank you.
There's no question that the employees of the District Attorney's Office should reflect the communities in which they serve. I'm proud to say that my hiring director is a woman of color with deep roots in the affinity communities. And she does an outreach across the state and across this country to attract the best potential DAs to our office who are members of diversity communities. And to show how seriously we take that, she's often accompanied on her travels by a retired Superior Court judge who works in our office and who really can bring the gravitas of the office and the work that we do there. Additionally, we have an affinity group within our office that really serves as a safe space for people to talk about things that may be part of the implicit or explicit bias in an office, to get perspective, to talk about all of those questions and things that may be difficult to raise in other places. Among the affinity group's functions are to encourage mentoring, provide access to members of the community, leaders in those various communities that can help us to attract and retain members of communities. And we also support by paying all of the dues for the affinities bar groups so that we have an opportunity to be in the best contact with people who may steer folks to us and then keep people in our office.
Thank you.
It's not just about recruiting, but it's also about retaining. If the Middlesex County DA's office is losing 15% of its experienced prosecutors...
Wait. Oh. I boo-booed. My mistake.
I'm sorry.
I made a mistake. I allowed a rebuttal. We're past that.
My apologies.
My apologies. I let you. And anyway, it's on me. We are going to begin last three questions. Last three questions. Sealing and expungement of criminal records can be critical to reentry efforts, so returning citizens can get jobs, housing, and an opportunity to succeed. What is your policy for when your ADA should or should not object to petitions to seal or expunge records? Marion Ryan, please.
I was supportive of the provisions regarding sealing and expungement in the Senate Criminal Justice Bill, and I supported the ones that made it into the Criminal Justice Bill. We would have to have some extraordinary reason to oppose those kinds of petitions.
Indeed, the changes to the expungement law in particular are critically important because I, both as a defense attorney and as a prosecutor, tried to get records expunged, and I was never able to be successful because the burden was so high. As I said, I've seen firsthand the difference that sealing records can make. I will also proactively move to seal the records of folks, as I did when I was volunteering for the Women Bar Association, of folks who had convictions for marijuana possession.
Thank you. What would you do to ensure that law enforcement officials are held accountable in cases of potential misconduct, say misusing timesheets or shootings? And that is to Donna Padalano.
I will have a Public Integrity Bureau that will investigate officer-involved use of force and will also investigate misconduct by public officials. There's nothing like that right now in the Middlesex DA's office, and it's rather random which cases get investigated and which ones don't. So a domestic violence shooting by officers in Reading last winter has been investigated. But in Cambridge, when a Harvard student was sucker punched by the Cambridge police on the ground, that's not being investigated by the Middlesex DA's office. What's being done instead is the Cambridge police are leading that investigation. We need to make sure that we have a protocol in place before these incidents happen so that you can trust the district attorney's office to look at this in an unbiased, objective way. And then that information needs to be released. I also will work to make sure that we get body cameras on police officers. That's something that's not happening right now in Middlesex County. My nephew is a police officer. He just graduated the academy in August back in Rhode Island. He learns from his body camera footage. He looks at the footage and understands how he can better address issues as a new recruit. Imagine what we could do if we could have that happen in Middlesex County. I will push and advocate that we get those body cameras in place.
Thank you.
So we have in place in the Middlesex District Attorney's Office a Special Investigations Unit, which investigates those kind of public corruption, misuse kinds of cases. With respect to an incident that may involve a death and a police officer shooting, those cases are initially reviewed by my chief of homicide. They are then reviewed by a senior group of prosecutors in our office, and then there's ultimately the decision made by me as to whether or not charges are warranted. Since I've been district attorney, there have been 4 such incidents. The reports of those have been released. They're available on my website. Each of the 4 are been out there and released. readily accessible. With respect to the Cambridge incident, you know, one always has to take a step back and think about, what is my role here? What is the goal in the investigation? And also, what is my voice? Again, I'm a white prosecutor. I'm not a member of the community who's been harmed by what happened or who's afraid about what happened. It's easy to jump out and be making statements. That's not always the goal. The goal is to have a thorough, fair investigation that is perceived by the community. I was involved in that investigation from the very beginning and was a part of brokering a deal where, because there were injuries but not death, an investigation will be conducted by the Cambridge Police Department. It will then be submitted to Justice Ireland, and if necessary, come to our office. And I commend to you the statement for the attorneys and the victim in that matter. You don't have to take my word for how well we accomplished that goal.
Final question, beginning with you, Ms. Ryan. Massachusetts has just passed an omnibus criminal justice bill. Massachusetts has just passed the omnibus criminal justice bill, but it didn't do everything. What other changes in legislation or in the policies and practices of the DA office would you like to see?
So I am happy that the bill got passed, but you're right, there are things that are missing from that bill. It didn't go far enough, I think, with respect to the juvenile courts. It didn't go far enough with respect to mandatory minimum sentences. There are certainly other pieces of the criminal code that need to be altered and changed, and that's part of the conversation and the work that we'll be doing in the next 3 to 4 years as we live into this new bill.
Thank you.
The criminal justice bill was an amazing step forward. But one of the powers of the district attorney is sometimes you don't need to wait for legislation in order to make things happen. So the way that the prosecutor has unfettered discretion to make the mission of the office is something that I want to take advantage of, because this is what I hear from folks in the community. Let's change civil asset forfeiture. We can change it so that assets are not taken from defendants until they are convicted. We don't need to wait for legislation. Unless a drug dealer is dealing to a child in the middle of a school day, there will be no school zone charges in my office. School zones were meant to keep kids safe. Instead, they're a failed experiment that has ended up in infecting our justice system with racial and economic disparities. We don't need to wait for legislation. We can make those changes in the district attorney's office if you elect somebody who is interested in bringing a different perspective and interested in bringing transformative and transparent change in a way that isn't happening now.
And I think those comments are clearly leading up to our closing statements. We'll begin with 2 minutes for Mary and Ryan.
Thank you. Thank you all for being part of this fruitful conversation tonight. But ladies and gentlemen, let's be honest. This conversation tonight has been among people who share progressive values, who share a similar worldview. Even though the criminal justice bill has been passed, the hard work that remains ahead of us is going to have to be led by someone who can effectively have those conversations with people who don't think like we do. We have lots of very persistent, vocal, powerful opponents to fixing our criminal justice system. So the question before you is, of the 2 candidates that you'll choose from on September 4th, who has the credibility and the gravitas not to talk to the people who think the same way, but to bring together and to work with and get to a different place with people who don't think that way? I am uniquely positioned to do that. My credibility as a prosecutor, as someone who's already done this work and moving this bill to this point, much of the changes in my office, my experience as a victim and a witness to a violent crime, earned me credibility among those folks who don't feel the same way that we do. It has enabled me to build across this county coalitions and partnerships that get the work done. It is a fight. I have taken the hard stands. I've stood apart from the other district attorneys. I've opposed ICE. That's what we need. At the end of the day, I'm a kid from Somerville. I've got the fight. I have the scars from that fight. I'm proud of what we've done, and I want to continue doing that for you. Thank you so much for being here tonight.
Thank you. And closing statement from Donna Padalano.
Thank you again, and thank you, Marianne, for coming tonight. I'm excited to share my vision. This is a national movement. This is a new conversation that has never happened before in Middlesex County. We have an amazing opportunity here to make sure that we have a justice system that doesn't treat different people differently. All we have ever demanded, if we have demanded anything from our district attorneys, is that they be law and order candidates. It's time to stop that because we know we do have a justice system that treats different people differently. I'm looking to bring transformative and transparent change. You heard some talk today about data. You heard about the yes and no answers. Yes, releasing the information about asset forfeiture. Well, how come that hasn't happened? She hasn't done it, I will do it. She's had 6 years to do something besides leadership by letter. We need to have a district attorney who's had different perspectives. My grandmother used to have an expression. She said, when you're a hammer, everything looks like a nail. I've been in the jails. I've represented people who don't look like me. I know that our system is infected with racial and economic disparities. This race is going to be decided by the best, most progressive voters in the country on September 4th. This is our opportunity to say we want to demand of our district attorney, of me, that you be transparent and you be accountable. This is just not a walk I'm walking. This is a life that I've lived. And I am telling you that we can do it. I have done the work as a manager, as a prosecutor, and as a defense attorney. I didn't do any one of those things because I thought I'd be honored enough to be here asking for your vote on September 4th. But I'm telling you, I will be a better district attorney, and we will have that transformative and transparent change because you vote for me on September 4th.
Thank you. And now is your opportunity to give a big hand of applause. And we just have a few more announcements for you. So we have just a few more announcements for you. If Rahsaan will come to the lectern. Do a better job than I did with that.
Is this loud enough? Good evening, everyone. My name is Rahsaan Hall. I'm the director of the Racial Justice Program of the American Civil Liberties of Massachusetts, American Civil Liberties Union of Massachusetts. Give yourselves a round of applause for coming out tonight for such a spirited and important debate. As I see you all making your ways to the exit, I'll try not to keep you long, but there are a few important things that I'd like to lift up. Let's give another round of applause to our candidates tonight for candidate for district attorney, Reverend Ryan, Dr. Catalano, also candidates for the Governor's Council. Give a round of applause to our wonderful moderator, Ms. Patty Muldoon from the League of Women Voters. And for all of the individuals and organizations that made this evening possible tonight. Let's just a general round of applause and then I'll just kind of list them. We want to acknowledge the media sponsor, ACMi. We'd like to acknowledge the Mass Incarceration Working Group of First Parish Unitarian Universalist of Arlington, the League of Women Voters of Arlington, Lexington, and Winchester, as well as the ACLU of Massachusetts and our What a Difference a DA Makes campaign. This is what democracy looks like. You all The reason that this is so important, or evidence that this is so important, or such an important part of democracy, one of our state representatives, Sean Garbely, the representative from Arlington and Medford, is here this evening. He came all the way from the State House to see what was going on. There are about 400 people who said they were going to come. We counted 396 who are here this evening. You all should count yourselves as a part of history. The things that have been discussed here tonight are historic in nature. The amount of people who have come out this evening is historic in nature, not only here in Middlesex, but throughout the Commonwealth. There are currently 6 contested DA races throughout the Commonwealth of Massachusetts. The last time there were 6 contested DA races in 1 year was in 1982, and that was when we were ramping up in the war on drugs. And now 36 years later, we find ourselves with the same amount of contested races, and we're looking for a new approach and a new model and a new way of prosecution. And from what you've heard here this evening, I trust and believe that these candidates have given us a lot to think about. For you all who are Middlesex residents, Middlesex County residents, you have a lot to think about, a lot to mull over, and there are ways to find out even more about the candidates. Certainly go to the candidates' websites, reach out to the candidates, speak to them individually. I'd also like to direct your attention to my colleague in the back, Liv Santoro from the ACLU. There are pledge cards, voter pledge cards. My trust and inclination is that you all are here and that you all are going to vote, but it's always good to have a little reminder. Every time we go to the dentist and we schedule an appointment, they give us that reminder card, right? Or they send us that text message. Well, if you fill out one of these voter pledge cards from the ACLU, What a Difference a DA Makes campaign, we will send you a reminder about the September 4th primary to make sure that you are reminded to turn out, because really, that is the day after Labor Day, and it's the first day of school for a lot of places, so a reminder is not going to be a bad thing. There's also an opportunity to sign up to find out more about these candidates, but also to get engaged with the work of the ACLU. You can participate in canvassing, you can participate in court watching. There are more debates. The questions to our candidate surveys that both of these candidates filled out are on our website at www.dadifference.org. I'm really pleased and honored that you all came out here this evening on behalf of the ACLU and our executive director, Ms. Carol Rose. We have invested a lot of time and energy working with a large array of community partners and organizations, including the Mass Incarceration Working Group of First Parish Unitarian Universalist of Arlington, as well as Greater Boston Interfaith Organization, the NAACP, the Massachusetts Bail Fund, Prisoners Legal Services, EPICA, Ex-Prisoners and Prisoners Organizing for Community Action. It is a broad-based 501c3, nonpartisan, non-electioneering, community-based public education campaign. One of the things that we found out last summer when we did some polling is that 38% of Massachusetts voters did not know that this was an elected position. That's almost 4 in 10 Massachusetts voters didn't know. But one of the things that encouraged us was that when we did that polling and confronted people with this information, 81% said that they would pay more attention in the next district attorney election. So I am here pleading and encouraging you to engage your neighbors, to engage your friends, to talk about this race, to talk about what you saw here this evening, to share the video content that you can find on our website, to share the video content that will be available through ACMi, as well as other local community access television networks throughout Middlesex County. This has been a tremendous event. This has been a tremendous turnout. I applaud you all. I encourage you to stay engaged in this conversation and continue to push this conversation forward. Hold these candidates accountable, not just up to the September 4th election, but also on the November 6th general election, because those votes matter as well. But not only at the November 6th general election, but well after that. because these things that have been discussed, we need to hold them accountable, whoever wins this race. You all are the body of people, the body of believers, the body of people that are going to go out and do the work to hold them accountable to the things that they have said here, to the things that they have responded on candidate questionnaires. And they need to hear from you all, the people that help put them in these positions. So thank you again for coming out. A last round of applause for everyone who has participated. Thank you.